Gartland Law presents Taxes, the IRS, and You with your host, Bernie Gartland. Taxes, the IRS, and You is a different kind of show that'll help you solve your tax problems. As former Deputy Attorney General of the state of Delaware, and with over 25 years of experience as sole practitioner in both Delaware and California, the name Bernie Gartland has become synonymous with taxes. And now your host, Bernie Gartland.
Hey everybody, Bernie Gartland. The name of the program is Taxes, the IRS, and You. And here we are with our resident in-house panel, Dave Wiesen from Gartland Law, who is a tax attorney, and Brian Bauer, who is a CFO and principal in American Tax Centers. Now, tonight, we're going to talk about something that nobody knows about. Hopefully, guys, we know about it. It's called dischargeability of taxes in bankruptcy. Now, wait a minute. Everybody knows you cannot discharge taxes in bankruptcy. Raise your hand. Everybody that knows that you can't discharge your taxes in bankruptcy, raise your hand. Because you know why? Because you've been told by tax attorneys, bankruptcy attorneys, your banker, your next door neighbor, that taxes cannot be discharged in bankruptcy. Now, Dave?
If you meet the requirements of a couple of sections of the bankruptcy code, taxes actually are dischargeable in bankruptcy.
They are dischargeable in bankruptcy. As a matter of fact, we've been doing it for a lot of years, okay? And as you know, I was the first attorney in 1988 to get in front of a judge to tell the judge that taxes were discharged in bankruptcy.
Did he agree
and
with
he
you?
didn't believe it until I quoted him the code, and he slammed the gavel down and he said, recess, and he came back in and he went out and read the code. And there's two sections of the code that really apply. What sections are those?
The priority section, which is section 507, and then the section regarding discharge, which is section 523.
Right, so we can colloquialize and say there's two sections of the bankruptcy code that apply, section 507, 523. I know you guys and gals don't care about sections. All you want to know is, well, what are the qualifications of dischargeability? So if you combine section 507 and 523 together, there are three requirements, basically. There may be other ancillary discussions at some time, but what are the three qualifications that you need in place for taxes to be discharged in bankruptcy?
Sure. Well, the first requirement is the tax return has to have been due 3 years plus extensions. The second rule is that the returns have to have been filed for 2 years. And the third rule is that the tax has to have been assessed more than 240 days prior to filing the bankruptcy.
Okay, let's go into that first one again. The tax year has to be more than 3 years old plus extensions. So if you file an extension for 01, 02, 03, 04, it doesn't matter anymore because it's already been done. The second requirement is that the taxes have to be filed by the taxpayer. Remember in another segment that we had some time ago that we were talking about substitute returns, and this is where it becomes very important, doesn't it?
Sure, yeah. In section 523, it actually defines that if a return is done by the IRS under 6020B, substitute for return, then that's not going to be dischargeable under any circumstance in a Chapter 7 bankruptcy.
Or in a Chapter 13.
Unless it's fully paid.
And this is something that we're going to talk about in the future. We're now focusing on dischargeability of taxes in bankruptcy, but Brian Bauer, who is the CFO of American Tax Centers, he's going to talk at a different time, maybe next week or the week after, about the importance of filing your tax returns. And now it comes up to be very important because if the IRS does a substitute return for you, and even if you subsequently file a tax return, it is not a tax return for dischargeability in a Chapter 7, is it?
Right. Once it's a substitute for a return, the transcript of the account is always going to say substitute for a return, and it's never going to be dischargeable under these rules.
It can't be. And then the third rule basically is that it has to be owed or assessed for more than 240 days. So again, you get into a hypothetical. Suppose somebody owes 2005 taxes and they filed the tax return in 2007. Well, it's more than 3 years old plus extensions, and it was filed in 07. But it's still under audit. So if it's still under audit right now, today, and you decide to file a Chapter 7 bankruptcy to eliminate the 05 taxes, would they be dischargeable?
You need to wait until after that audit is completed and an assessment made from that audit, and then wait 240 days.
And there's another factor. As soon as this audit is done, what you have to do is you have to amend your California tax return with a 540X, And then it has to be posted, and you have to wait the 240 days. And California is really, really hard to get things assessed.
Yeah,
it takes months.
Yeah, if you submit an amended return, it could take 6 months, 8 months to get assessed.
So now, Dave, what happens if you meet the requirements that, let's say somebody owes $100,000, and you meet the requirements for the 3 years plus extensions, filed 2 years and 240 days, and that person has a house with, let's say, $30,000 equity in it. Now, they owe $100,000 for those years, and the IRS did not file a lien on that $100,000, and you went into a bankruptcy. What happens?
Well, it's discharged. Your personal obligation is no longer.
Okay, and there's no lien filed, so you don't owe the taxes anymore.
Fantastic.
Okay, now, let's say the IRS prior to the bankruptcy filed a lien. Isn't there a case, a Ninth Circuit case called ISM?
Yeah, your personal obligation is going to be discharged. However, the lien is still going to remain against the house.
Right, and then what you do is we call up the ISM person at the IRS and say, let's make a deal. Okay, so in other words, let me give you an example of Mr. Isom. Mr. Isom owed $900,000 in taxes. He had a house, they put a lien on it for, and he had $30,000 equity. So what happens, they get rid of $900,000 worth of taxes, and the IRS says, yeah, the personal obligation is gone, but there's $30,000 equity, and the lien still survives the bankruptcy of $30,000. You know, I have an expression, hey, give me $900,000 every week, I'll give you back $30,000 every week. Now, Brian, how do you fit into this situation? Why is it important that we have a tax preparation sister organization connected with the bankruptcy organization?
Well, it's important because one of the requirements of filing bankruptcy is the trustee is going to want the current tax return completed so that they can review it to find out if there's any liabilities there. Mm-hmm. And if they go somewhere else, like if they went to a different law firm, they would have to go out, get the return done, then come back and proceed. Here, it's all in-house. Just walk across the office and I do the tax return and give it back to the bankruptcy lawyer.
If you don't file if you're not up to date with filing your tax returns, the trustee in the court will dismiss your case.
Right. Can't
in
do
other words,
bankruptcy.
you are not going to be able to even take advantage of the dischargeability if you don't have your tax returns done. And the interesting thing is, Dave, you and I run into this a lot of times with other bankruptcy attorneys out there have to send their clients to some tax preparer, and you lose control over getting this in. And usually we have a rush matter when we have a tax problem because of levies and liens coming down.
Sure, yeah. Or maybe you have a foreclosure coming down.
And a foreclosure coming down. So it's really neat that we walk 15 feet to Brian and say, Brian, I want to introduce you to Mr. and Mrs. Smith. Oh, by the way, here's their W-2s and so forth and so on. And what we can do at that point of time, we can send for and analyze the information from the IRS to make sure they comply with these qualifications. And by the way, Dave, one of the questions that comes up is, and we're going to answer this question after the break. Well, wait a minute. We've always been told that you can't discharge taxes in bankruptcy. Why do you guys know this and nobody else? And I'm going to tell you that as soon as we come back from our break.
Visit us on the web at www.gartlandlaw.com.
Hi, everybody. I'm Bernie Gartland. Let me introduce you to Kimberly and Brian from American Tax Centers.
When filing taxes, you want them done quickly and accurately.
We have over 24 years of tax preparation experience. And speaking as a former state auditor, we know accuracy.
Whether it's current year or prior year tax returns, we know that our experience will work for you.
So call us today for a free consultation and peace of mind to know that your taxes are done right.
Hey everybody, Bernie Gartland. Name of the program is Taxes, the IRS and You. And if you want to go to our website to find more about offering compromises, dischargeability of taxes and bankruptcy, anything you need to know about your IRA and other areas, go to www.gartlandlaw.com. what we also like you to do is take time to email me and let me know what subjects would you like us to cover in the future. You know, you guys and gals are very important because you guys and gals have the problems. We have the solutions, and we need to know from you, what do you want us to cover? So my email is bernie@gartlandlaw.com. That's bernie@gartlandlaw.com. I check my email 15 million times a day. So give us an email. Let us know how you're enjoying the program. Let us know what you want us to cover, or whether or not you need our services, obviously. Talking about self-serving, you know, that's what we're here for. Now, Dave, before we went to the break, we had outlined the three basic rules. The three basic rules are the taxes to be discharged have to meet three basic rules. One, the tax year has to be more than 3 years old plus extensions. It has to be filed for 2 years by the taxpayer, not by the IRS, and it has to be assessed and owing more than 240 days. The question always comes up is, wait a minute, what makes you guys so important and so knowledgeable? I've been told that you can never discharge taxes in bankruptcy, and are you saying that it's in the bankruptcy code somewhere? Yes, I am. Well, if it's in the bankruptcy code and we go to bankruptcy attorneys, well, how come they don't know it? Well, there's a reason. First of all, tax attorneys don't understand bankruptcy. Bankruptcy attorneys don't understand taxes. Guess what? That's what we do collectively, okay. But folks, we're gonna read you the two sections of the code that apply to the three principles, and I defy you to understand what the legislators put here. So I've asked Dave, because he has such a very good, slow, methodic voice, he's going to read you what these two sections say. And remember, if you understand, I want you to raise your hand. Okay, go ahead, Dave.
Okay, 507A8. A tax measured by income or gross receipts for a taxable year ending on or before the date of the filing of the petition. 1, for which a return, if required, is last due, including extensions, after 3 years before the date of the filing of the petition. 2, assessed within 240 days before the filing of the petition, exclusive of any time during which an offer in compromise with respect to that tax was pending or in effect during that 240-day period, plus 30 days, and 2, any time which a stay of proceedings against collections was in effect in a prior case under this title during the 240-day period plus 90 days. This is section 3. Other than a tax of a kind specified in section 523A1B or 523A1C of this title, not assessed before but assessable under applicable law or by agreement after the commencement of the case. And then 523 talks about exceptions to discharge.
And you have to have, for the dischargeability, you have to qualify under both 507 and 523. So
right.
This is the other statute, and I'm sure that everybody understood word for word what that first is. 507
it's crystal clear.
I mean, crystal clear, okay.
Okay, so 523, a discharge under section 727, 1141, 1228, 1228B, or 1328B of this title does not discharge an individual debtor from any debt. 1, for a tax or customs duty, A, of the kind for the period specified in 507A3 or 507A8 of this title, whether or not a claim for such tax was filed or allowed. B, with respect to which a return or equivalent report or notice, if required, 1, was not given or filed, or 2, was filed or given after the date on which such return, report, or notice was last due under applicable law, under any extension, and after 2 years before the date of the filing of the petition. And then there's another paragraph pertaining to the 6020B, but that's why it's a little convoluted, is because. And
this is exactly why when I gave a lecture one day, and this couple came up and said, you know, we didn't know that taxes were dischargeable in bankruptcy, but we're moving to Phoenix. And I said, well, when you get to Phoenix, go interview a couple of bankruptcy attorneys, you know, and tell them that you owed all this money in taxes and everything. So several weeks later, they called me up, and they said they went to 4 bankruptcy attorneys and told them that I didn't know what I was talking about, that taxes can never be discharged in bankruptcy. The 5th one said he was practicing bankruptcy law for 15 years. He didn't know about it, but he was willing to talk to me. So I called him on the phone, and I introduced myself, and I told him that the clients were part of a lecture I gave. And I said, "You've been practicing bankruptcy law for 15 years and you don't know the ins and outs of dischargeability of taxes?" He says, "No." He says, I said, "Why don't you read section 507 and 523? He said, "Well, I have to go to court now. But I certainly will call you back." Well, I know what happened, Dave. What do you think happened? Huh?
He went and looked in the code.
He went out and looked in the code because he didn't know. He calls me back, and he said, "I just read the code, and it tells you all that you can't discharge in bankruptcy." That's how we read it. And I said, "Well, if the code section tells you what you can't discharge in bankruptcy, doesn't it have logic? Doesn't it make sense that you can discharge taxes in bankruptcy?" He said, "Well, I don't read it that way, so I'm not doing it." So, and I mean, this is the problem we run into. Fortunately, down here in the Coachella Valley where we're at, most of the bankruptcy attorneys down here understand that this is very, very convoluted because, and so what they do is when somebody comes into their bankruptcy firms, they send them over to us because of the convolutedness of the bankruptcy connected with taxes. The interesting thing is that, remember we talked about it in another program about sending for and analyzing all the information?
Sure.
Okay. Now we were sending for and analyzing the information for the purpose of Brian to do the tax preparation, but don't we also do that in conjunction with doing what for bankruptcy, Dave?
Well, we need to know these important dates. We want to know, one, whether the tax was prepared by the taxpayer or whether it was a substitute for a return. We want to know whether there were any subsequent assessments, like if there was an audit or something. We want to know, were these people ever in an offer and compromise, because an offer and compromise extends the 240-day rule. We want to know whether a collection due process hearing was ever filed, because that also extends the time. And those are some of the things that we want to look for.
So in those three time periods of those qualifications, a certain amount of those time periods that are necessary could be halted for a period of time because of 507 and 523. And unless you send for the transcript of account and know how to look at them and read them,
right.
All right, for instance, you just said offer and compromise. How many people know that the code number is a 480 code? You have to look at the 480 code and you have to look at 481 code. But there's something else. That is, we file it, it's a 480 code. It is rejected, it's a 481 code. But you have to add time to that. That's not just the period. So this is why the bankruptcy firms do not practice within this framework, because they don't know how to do it. And they don't know how to do the tax returns that Brian does. Now, folks, when we come back, we gave you the preliminaries of dischargeability of taxes in bankruptcy. Now we're going to spend the next segment, and we're going to talk about strategies. We're going to talk about how to accomplish what we need to accomplish. And oh, by the way, what is a Chapter 20 in bankruptcy? If you go look it up, you won't find it, but there is a Chapter 20, and we'll come right back.
Stay tuned. Bernie will be right back with more tax solutions.
Well, it's that time of year again. Yes, it's tax preparation season again. Hi, I'm Bernie Gartland. For years, we at Gartland Law have been preparing your prior year's unfiled tax returns. Well, we also have the ability to do your current year tax preparation. If you haven't filed tax returns for several years, or you simply want us to prepare the current year tax return, we can help. Call us today to set up your tax preparation appointment. Hey everybody, Bernie Gartland, welcome back. This is called Taxes, the IRS and You, and we're here every week to talk about asset protection, dischargeability of taxes in bankruptcy, three-part problem-solving process to get you who have not filed tax returns in several years. By the way, do you know there's over 31 million people that have not filed tax returns in 3, 4, 5, 10 years? That's what we work on. That's what we've been trained to do, is to find out what the IRS knows about you so we can prepare the tax returns to get you back in compliance to take a look at the different options that we talked about at another time. And one of the options we're talking about right now with David Wiesen, who is also a bankruptcy and tax attorney, and with Brian Bauer, who's principal in American Tax Centers, who does the tax returns for people who haven't filed. We're going to talk about strategy. Now, Dave, we talked about after we get the people in and we get the tax returns done, a lot of times people come in and say, I already owe $125,000 for 01, 02, 03, 04, 05, but I haven't filed 08, 9, and 10. We get them to Brian. Brian does the tax returns. And let's say hypothetically for 8, 9, 10, 11, they owe $15,000. But they owe a gazillion dollars for these earlier years. They got 2 repos. They got a foreclosure on the house, and that's another issue for another day about what the tax ramifications of foreclosures are. But in other words, the person needs right now to go into a Chapter 7. Well, under that scenario, the 01, 2, 3, 4, 100 and some odd gazillion dollars is dischargeable. But what about the $15,000 or $20,000 that don't meet the requirements? What can you do for a person in that category?
Well, the taxes that wouldn't be dischargeable, obviously we need to make sure those taxes are prepared and filed. Those are going to remain after the bankruptcy, but the good news is while you're in the bankruptcy, Section 362, the automatic stay, prevents any collection while you're there. So good things are going to happen while you're in your bankruptcy of getting the discharge of that large amount of money, taking care of the repossessions, taking care of any judgments you might have against you, and also stopping that foreclosure. But what we're going to be able to do is on the other end of the bankruptcy, then a Chapter 13 might be available.
Wait a minute. You're saying you can file a Chapter 13 after a Chapter 7? I thought you can't file another Chapter 7 for 8 years.
Well, the reason why most people file a Chapter 13 is because they're looking for a discharge. Okay, basically if they make it through the plan, the 5-year plan, they get a discharge.
And then the interesting thing is we're not talking about 8 years for a Chapter 7 because we're talking about what? A Chapter 13, which we commonly refer to as a Chapter 20. But I listened to a CD once that unfortunately the bar put out with this lady who is the guru in bankruptcy. She says you can't file a Chapter 13 for 4 years after a Chapter 7. And I thought she was going to put a comma at the end of that, and she didn't. What is the rule with that, Dave? And why can we put somebody in a Chapter 13 immediately after a Chapter 7 for the $15,000 to $20,000 that was not dischargeable, and we don't have to wait the 4-year requirement? What is the rule?
Because we've gotten rid of all the credit cards and other things, all the messy stuff. All that remains is a non-dischargeable taxes. Right. So in the Chapter 13, we're going to be able to just focus all their attention on their plan payment on paying down that $15,000.
Okay, so you can set up immediately after the Chapter 7, you can set up a 100% payment plan. In other words, what survived the bankruptcy has to be paid dollar for dollar for dollar for dollar over a 5-year period, 60 months. You don't have to wait the 4 years because you're not asking for a discharge. You're asking for a court-supervised payment plan. The key is what you said before, Section 362. Section 362 prevents any creditor, including IRS, Franchise Tax Board, EDD, from coming after. They can't call the client. They can't come to the front door. They can't attach wages and so forth. So a practitioner that, number one, doesn't understand about dischargeability, or does understand dischargeability but doesn't understand you can take those taxes that are non-dischargeable and put them in a 13, will simply say to the client, oh, well, after you get discharged from the Chapter 7, the IRS is going to show up at your front door and deal with it.
Good luck.
Okay? Well, that's not what we do.
No.
We put them in. Now, let's say we get a client in, and Brian, you're going to do taxes for many, many, many years. And let's say the client already owes for 04, 05, 06. He owes lots of money for the taxes. And we do a tax return, let's say they're so broke they can't even pay attention, okay, in this year. So they're not going to owe for 11. They're not going to owe for 10. But for, let's say they did not file their 2007 taxes, and that was one of the biggest years they had, and they didn't want to file their tax return because they knew they owed other taxes. So you do the tax return for 07, 8, 9, and 10. And for 07, they owe like 60 some odd $1,000 in taxes, ad penalties, and interest. So, Dave, if you do a Chapter 7 bankruptcy now, because Brian's just filing the tax return for 07, and you do it now, what happens to that $60,000, $70,000 that is now owed for 2007?
Now you're stuck. Now you're stuck owing the money for 07 plus the other later years. So maybe filing that Chapter 7 right away to get rid of the older years wasn't such a good idea.
Okay. And we're aware of that. And that's the purpose of having the bankruptcy department, the tax preparation department, the IRS problem solving department is this reason. At another time, we talked about something called CNC, currently non-collectible. If your expenses equal to or exceed your income, the Internal Revenue Service has to leave you alone. Now remember, you talked about interrupting the statute from running on certain cases. Does an installment agreement stop the time period?
No, it doesn't.
No, it doesn't. So what we do is, 7 is more than 3 years old plus extensions, but it's not filed for 2 years.
Right.
So if we wait 2 years, and what harm? No harm, because the currently non-collectible doesn't stop anything from running. So we put together a game plan to get that person 24 months down the line. Then, and the 240-day rule is complied with. What happens at that point?
Well, then they're ready to file the bankruptcy. They'll get rid of those older taxes that would have otherwise been discharged. Now we've converted 07 into a year that can be discharged as well.
Right.
And now they're in a good situation. The only money that's going to be owed at the end is just going to be the money for 8, 9, and 10, which was a little anyway.
And by the way, you know who Tim Berry is. He's one of our associates. And Tim and I have done analysis that sometimes in certain situations you can have a taxpayer that earns $40,000, $50,000, $60,000, $70,000 a year if they meet the certain requirements with several kids and different other things. That even making that kind of money, you can be put into a CNC, currently non-collectible.
Absolutely.
So the whole key of tax problem solving is when you find that you have a tax problem, there's just not one little option. Like everybody says, well, we'll file your tax returns and go down to the IRS. What is done at Gartland Law and American Tax Centers is we embrace everything connected to your problem, and we come up with solutions. Go to gartlandlaw.com and find out all the areas that we can represent you in to get you back in control of your life. And we say, don't we? When you come to see us, it's not a matter of good credit versus bad credit. It's a matter of how do I get control back in my life, and how does that control give me a future? So we're here to work with you. Brian's here to do your tax returns for you. Dave is here to do intervention with the IRS for you and set up strategy. We always think outside the box, and we're here to represent you. So anyway, I want to thank Dave for being here. You're our regular panel anyway, and Brian, our regular chief, what I always call you, the chief legalese, right? Yeah, I know, everything. So anyway, thank you very much for tuning in. We're here next week, and we'll be talking to you about different other subjects that are going to be interest to you and value to you. And remember, no more sleepless nights. This is Bernie Gartland. Good night.